Good evening, ladies and gentlemen. Please lend me your ear. We have an excited panel coming up. There is enough time for networking and chatting afterwards, but please, let's give a chance to the panel. Welcome. There are some seats. Maybe you can do a show of hand if there's a free seat next to you, so people... Okay, there's quite a few, especially here in the middle. Great, thank you. Welcome, everyone. My name is George Fürlinger. I'm one of the co-directors of Open Austria Initiative. Our mission is to connect Austria and Silicon Valley. On behalf of our whole team, who is dispersed all over the room and made this event happen, and our EU colleagues, it's a pleasure to welcome you here at Galvanize Co-working Space, which is also home to our office over there in the corner. You can see the Open Austria logo. As you might know, Austria is currently holding the EU presidency, and Open Austria has the local chair in the Bay Area. For this reason, we are hosting tonight's event on this important issue of data privacy. And it's an important issue because otherwise it wouldn't be so many people coming here. So that's really great to see. And we do this together with, but also on behalf of the European Union, given Austria's special role in this year. And without further ado, it's a special honor to introduce you to Peter Vatelnik, who is in charge of digital economy policy at the EU delegation in Washington, D.C., and who is partner and sponsor of tonight's event. Please give a warm welcome to Peter.
Thank you very much. Greatly appreciate. Thank you, Georg. It is the first time the European Union is partnering with the official representation of the European Union member states here in Silicon Valley. But I'm certain it's not going to be the last time, because if I see the interest in the topics we are discussing, I think this is something we would like to partner with and be part of the conversation. I particularly would like to welcome the Consul General who joined us today. Thank you for coming. Greatly appreciate your support in these events. I only want to make a short statement to the topic, which is actually a quote, so it's not even from me. And I would like to quote the Charter of Fundamental Rights of the European Union, and in particular Article 8, because this is what we talk about today, and I think everybody should be sort of understand the absolute value we are talking here. It reads as follows: everyone has the right to the protection of personal data concerning him and her. Full stop. Full stop. There is no however, but, maybe, or whatsoever. That's where it stops. There is no other condition on it. That's it. And I think this is something, if we have this conversation today, something I would like you to keep in mind. However, now is right the time to move on to the panel conversation. And at that stage, I would like to pass the microphone to the host, Martin Rauchbauer. He is the Consul General of Austria here in San Francisco, and he is the co-director of the Open Austria Initiative in Silicon Valley here. Oh, you have your own.
So thank you very much. Does one hear me? Microphone might actually take your microphone. So thank you very much, Peter. Thank you very much for you all to have come here just one day after the midterm elections. We were not really sure how the turnout was going to be tonight, and it's I think if the midterm elections and tonight have one thing in common, it's the high turnout. And it actually points to a serious point, and that is I think what we are increasingly noticing is that citizens, people, care increasingly and more about politics and about policies. And we here in San Francisco, close to Silicon Valley, we notice that with the rapid advance of technological changes, there is also the need to find responses to these changes, whether they are legislative responses, regulatory responses, or responses by our societies to these changes that affect our societies already now and are certainly going to affect us even more in the future. And data privacy is one of these issues. Just to make a very, very quick recap, the European General Data Protection Rules, our GDPR is a very well-known thing now around the world. In the spring, in May, when it was enforced, before and after, most of you probably, like me, received tons of emails, some of them annoyingly telling us to change something. So that was that was one way. If you were an entrepreneur, of course, if you were a tech company, you had to make changes, and those changes you had to better do well in advance. But then in California, a lot of things happened since May. There was a popular ballot initiative that led to the California Consumer Privacy Act that was passed over the summer. And after the summer, there was a discussion already in the US Senate to whether or not to enact a federal privacy legislation. And there were 2 Senate hearings in the Commerce committees. You've mentioned them, and Dr. Jelinek was testifying in one of them. So we have here a very, very interesting panel assembled to talk about these developments. I want to just quickly mention, if you want to tweet or if you want to use social media tonight, we put it under the title of our event, hashtag Silicon Valley meets GDPR, or SV meets GDPR. And I want to, without any further ado, proceed to introducing to you the panel. So on my right, there is Dr. Andrea Jelinek. She is the head of the Austrian Data Protection Authority and was elected chair of the European Data Protection Board. I think the term is 5 years, if I'm correct. And she is kind of the EU chief regulator, and we're going to talk a little bit about that on GDPR. We're going to talk a little bit about the mechanism of EDPP and also a little bit taking stock of the first experience after 6 months. To her right is Chris Riley. He's the Director of Public Policy of Mozilla. Mozilla, a very interesting case, a very important tech institution. It's not for profit and well known for some of its applications like Firefox, and has taken a largely positive view on GDPR, and we're going to talk about that in a minute. To my left is Liane Keulemans, the Vice President of Global Privacy of Salesforce. And we met just recently at the well-known Dreamforce event. And I think what Salesforce has been doing over the last years is really taking an active approach, not only towards privacy, but also towards discussing policy issues with all concerned stakeholders. And I think it is fair to say that Salesforce has been taking a largely positive view on GDPR as well. To her left is Mason Weiss. He is an international data protection lawyer, and he's a specialist also on comparing different international data protection legislations. We talked a few weeks ago when I was researching for tonight's event, and I could see that you were an expert in this field, and we talked on the phone, and you immediately offered to jump on a plane because you're based in New York and come to tonight's event. So thank you for doing that, and I'm very much looking forward to hear from your perspective. And to the right, there is Cindy Cohn, the executive director of the Electronic Frontier Foundation. I want to make a personal comment of admiration for the institution and for you. Your EFF is a mythical institution, in my view. You've been personally named as one of the 100 most influential lawyers in the United States. You have been with EFF, I think, from its early beginnings, and have also been the lawyer in one of the cases, which was Bernstein versus the United States, which was about kind of freeing up cryptography. And you won that that law, and the EFF has, of course, been essential in the fight for freedom, civil liberties, human rights in the digital space. So I want to start with chronologically with GDPR, and so it's 6 months since it's enforced, 5 months, okay, May until now, and this gives rise to the question: what's the experience? Have you received a lot of complaints? Have you? How does GDPR fare after 5 months?
Does this work? Yes. Okay. First of all, thanks for the invitation. Thanks for your initiative to bring us closer together. I appreciated it. And first experience when the 25th of May was over was world is still spinning, because the preparation for the GDPR was like that everybody thought world will stop spinning because it was that hard for many people. But to be honest, workload of the national supervisory authorities increased as the awareness of the people increased with GDPR, and the supervisory authorities also adapted to the new law, to the GDPR, because not only the companies had 2.5 years to prepare for the entering into application of the General Data Protection Regulation, we also had these 2.5 years, and we used it for preparation. Staff increased, and our staff was educated too, because for them it was also an evolution like for the companies.
You often say that data protection did not start with GDPR. There was a time before GDPR, but what is the main difference?
The main difference is that before we had the Data Protection Directive in Europe, which was issued in 1995. So if you were already compliant with the directive, you didn't have to adapt quite a lot. But now the regulation is applicable in the same way in all of the 28 countries of the European Union. And so it's easier for companies too, if you just have to follow one set of rules, it's easier to be compliant than to follow 28 set of rules. And so I think it's really helpful to have one regulation which is into application for all over Europe. If you're going to make business in Europe, you just have to follow these rules.
So let's follow up on and get a little bit the views on GDPR from a Silicon Valley point of view. Following up with you, Chris, you're based here in San Francisco, Mozilla global platform for several applications. Would you say that the attitude towards GDPR and towards regulation in general changed over the last, let's say, year? And why do you think is that the case? And why has the tone become somewhat more positive?
I think that the enforcement of the GDPR in May of this year came at a very interesting point in time contextually. We've seen a sea change around the world over the past few years in terms of how government policymakers and, of course, the general public view tech and view how they feel the technology industry should be responsive to and responsible of them and their experiences online. So I think that there are principles that are represented in and reflected in the GDPR that are deeply felt among many, many people in many countries around the world. And that's why we've seen India, Kenya, and other countries working to adopt data protection laws in very much the same spirit and reflecting much of those same principles. Now, it's challenging, right? California is a very different environment. This is a culture that has spent the past few decades not putting that same level of scrutiny on how data is collected, how data is used. And that's why it's challenging for many people out here. Less challenging for Mozilla. As Martin said, we are different. We spent many years not collecting any data, willfully blinding ourselves to the things that we could learn from it out of a respect for the user's rights and privacy interests in that. We have actually been collecting more data over past years in recognition that there is a good way to collect and to use data, and trying to lead by example, I think in ways very much consistent with the principles of the GDPR. And I think that we're seeing that attitude more and more widely felt, and we're seeing that approach resonate more broadly, not just because of, but certainly in line with the GDPR and how it's being implemented.
Lian, on that point of this sea change that Chris mentioned, where does Salesforce stand in this?
Yeah. So trust has always been our #1 value. Obviously, we're a little bit of a different business model compared to, for example, Facebook or Google, right? When we get data from our customers, we act as a processor. So we're not using that data to do something else with it. But obviously, when we started as a company, the cloud was new, no one really knew what it's about. So there was a lot of how do you gain trust and how do you ensure that these customers give their data to us and then we keep it safe and secure. So that's always been important, which means that we had a strong privacy program. GDPR has obviously emphasized a couple of things and definitely, I mean, there are different things that we've been doing as a company. The first thing was really education. There are a lot of questions from everywhere, and definitely in Europe in the beginning, the smaller companies didn't quite know what to do yet. So we focused a lot on educating general public. The second thing that we did is we knew that our customers were going to have to comply with certain rights and obligations from data subjects. So making sure that within the service itself, there was that functionality available to comply with these rights. And then we collect as a company also data, right? Because we want to sell our services. So that was obviously the internal compliance. So GDPR has obviously helped to get internal attention, right? The fines are there, but fines are not really as to why you want to do it. You want to do it because you want to make sure that you build that trust with the end consumer. And I think that while maybe for Europeans, and I'm obviously European, that's been clear for a while, also the tech industry here totally gets that, right? They don't want to be named as the company that does crazy things with data. And obviously there's still these stories in the press and whatsoever, but just building a different relationship and ensuring that you take privacy seriously will actually, to a certain extent, help getting more data. And what I mean by that is we've done a little bit of research internally within Salesforce and talking to a lot of consumers and our customers. And on the one hand, there is this need for personalization and increased kind of one-to-one journeys, and you want your financial institution to call you and actually give you something meaningful. On the other hand, consumers are really concerned about what technology companies are doing with your data. So if you're more transparent and you want to be accountable and you want to really take these rights of individuals seriously, then you can see that individuals are actually willing to give more data. So ultimately, you should kind of just see it as an opportunity to build a different relationship with the consumer than to do it for the fines or seeing it as a headache, because that's no longer going to work. And I think Silicon Valley and the companies here have definitely understood that as well.
If you mentioned your customers, and Salesforce as a platform has lots of customers, big and small. Could you maybe also talk about some of the challenges that companies face now that Dr. Jelinek is here also to hear them? So there's always this discussion of, okay, this might work for big tech, about for small companies. How do they deal with regulation?
Okay, so I'm not necessarily talking about our challenges, but what I hear from customers. Um, what I always tell customers is think about what your risk is and what you're trying to achieve. And every industry is different. Like Salesforce is a very different company than a company that, I don't know, like a retailer or something, right? So it all starts with what is your business model? What are you trying to achieve? What kind of data do you collect? If you're a pharmaceutical, it's very different than for example, what we're doing. And then start thinking about what is the legal basis, like how can you be more transparent about what you're doing, like all of these things I think is where it starts. Where I think companies might struggle with is with some of the accountability principles. And what I mean by that is they don't necessarily want to be not accountable, but what does it mean to create a record of processing activities, for example, for all the data that you have? There are tools for that, and obviously there are a lot of companies that have a very big or dedicated privacy team like ours, whereby that's a little bit more easier. But for a smaller company, I think that might be more difficult, for example, to think through and actually have the internal investments. So maybe some of the more, don't want to say admin-related requirements, but some of these things might take a little bit more time to get on track. Security or data breach notifications is, I think, something that companies might struggle with, not because they don't want to notify, but obviously you need to have the right procedures in place internally, and they might panic and not fully understand when they need to notify. I think a lot of the notifications have been done more to be on the safe side than anything else, right? So just making sure really that some of these obligations that are out there, and I think that companies are really, they want to do the right thing, but what does it always mean? They're just getting the guidance, for example, from the European Data Protection Board on many topics has been super helpful. Yeah.
Mason, speaking about challenges and opportunities, you are a lawyer and in New York, and you have, as I understand, a lot of your clients are affected directly by GDPR. What is your, after 5 months, what is the kind of feedback you get from GDPR and data privacy more general?
Well, the process of getting ready for the GDPR was an interesting one for companies that were not already following Data Protection Directive and weren't already following an EU style of regulation. And to comply with such a broad-ranging set of very strict obligations requires real knowledge of what one is doing with data. What data is being collected, from where, why, where is it stored, where was it stored 5 years ago, what's that person in that office over there doing with it? Just getting knowledge of the current state, let alone figuring out what to do about it or changing it, takes a large effort. So, you know, that was a pain point for a lot of companies. However, many clients, you know, one piece of feedback that we hear a lot is that process was useful. Not just for GDPR compliance, but for compliance with US privacy laws, for taking stock of the data and understanding where it's going. It's not just, there aren't just compliance benefits for it, but there could be competitive benefits if you realize that, for example, that somebody's got a cookie on your website and you don't know why it's there, but they're collecting data. You know, maybe that's not consistent with your business's strategy. So there was a lot of in the process of building self-awareness, I think there was a lot of effort expended, but there was also a lot of benefit. And I think we, you know, now that the GDPR has taken effect, you know, as has been said many times, it wasn't an end; it was just a beginning. I think some other milestones that will change the response to your question a bit will be when, you know, when we start getting a lot of decisions and a first wave of enforcement actions. I think that's going to be a second awakening to the GDPR. So there's a lot of change.
So GDPR has taken a long while. There was a long process until GDPR reached its end version. I think it was a process of about 4 to 5 years. And in that process, a lot of stakeholders were involved, and I think the EFF was one of them, and an important one, as I hear. So I would like to know from you, Cindy, how you evaluate GDPR now that you were one of the main stakeholders, and how does GDPR fare in terms of civil liberties?
Well, EFF was through the EDRI, through the European Data Rights International organization. My international director, Danny O'Brien's in the front row, so I'm just watching for him to nod about whether I get this right or not. So we were involved and had been watching quite a bit about it. The GDPR has lots of things in it that are things that EFF has advocated for a long time. We have been concerned about the kind of rise of the surveillance business model that treats users as, that increasingly thinks that every single bit of information that can be tracked or gleaned about you ought to be gathered and organized so that you can be segmented into types and have ads placed to it. Not only because that in and of itself is creepy, but because it was creating a giant storehouse of information available to law enforcement. And that use troubles us quite a bit in terms of the standards of access for law enforcement to this information. So we have long argued for companies to consider what data they need to collect in the first instance, how long they need to keep it, and to get rid of it if they don't need it anymore. We think that makes good business sense because it's no fun when you're in civil litigation or the law enforcement comes knocking and you have to spend a lot of time and energy doing compliance. But I care a little bit about that. I care a lot about the users and how they get affected by these processes, which are often not visible to them at all. So to me, the GDPR, to the extent that it forces that kind of understanding and reckoning by companies about what they're collecting, how long they're keeping it, and those kinds of things, it's a good thing. We have some concerns about the right to be forgotten part of the GDPR, which to me is not much about data privacy and is vulnerable to some misuse. We think it's inconsistent with the First Amendment. So when we think about calls to bring the GDPR to the United States, I think there's some pieces of it that are not consistent with freedom of expression, not just the First Amendment, but actually freedom of expression in the international context as well that need to be paid attention to. And I think the other thing that we worry about is the world isn't made up of, the only people who provide technology to us is not corporations with giant compliance things. I mean, these are all, the folks up here have that. But EFF kind of works very closely with people in the open source movement, people who start things, people who are not big companies with big compliance overhead. And we want to make sure that we don't accidentally hurt competition and the ability for new players to come into the market as we roll forward with this. So we will be watching very closely the early decisions out of the various data protection folks to see whether they are recognizing that difference. And I do agree that privacy is a fundamental right, and so it should reside in all of you and not be dependent on whether you're talking to a big company or a small company. But I also think that we can't be blind to the fact that we could actually create a situation if we over-regulate here where the big tech companies that we have right now are the last big tech companies we ever have, because no one can scale the heights to get to a place where they can enter into the market. So I'm not saying the GDPR will necessarily do that, but there are some places in there where we're nervous, and we're especially nervous when we start looking at what's happening with some efforts to try to bring similar legislation around the world. And those will be the kinds of things where we'll either be cheering or you'll see us not cheering, depending on how the law gets applied.
So there's an interesting case which I read up. Some of you might have heard the name Max Schrems. He's a fellow citizen from Austria, and he he brought down the safe harbor agreement of the EU by suing, as far as I understand, the Irish data protection or Facebook, and he did it via the Irish data protection authority, and it went to the European Court of Justice, which then said that the safe harbor agreement was not okay and had to be replaced. And he now is he has now formed a not-for-profit organization called None of Your Business, and NOYB. And he has, I think, when exactly on what day did GDPR enter into force? It was May 25th. And I think the next day he sued 4 companies here in Silicon Valley: Facebook, Google, Instagram, and WhatsApp. And his point, if I understand it correctly, is the right to consent is not really, it's actually a kind of a forced consent because, and that point, that is, I think, a bit about your point. Some of these tech companies are so big that they have become necessities in our daily lives. It's not really a choice to be, for some people. For some people it is, but for some people it is not, to be on one of those social media platforms. And if you don't agree, if you don't consent to their regulations, you just simply cannot use them. So he has sued these companies for billions of euros, which is consistent with the 4% rule of annual revenues of GDPR. Now, I imagine you wouldn't want to comment on that, but maybe Cindy, or maybe you would, but what, do you think, okay. Even better.
Okay. Max Schrems is representing his NGO, NOYB, is representing 4 people, 4 countries. One is Austrian, one is Belgium, one is French, and the 4th one is German, regarding all these tech companies and regarding the consent. The files are on his website. The complaints are on his website in English and German, so you can read about that. And the point is, these complaints are, and this is a very good example for the one-stop shop mechanism of the GDPR. These complaints are investigated by the lead supervisor authority, which means the country in which the main establishment of the company takes place, and this supervisory authority has to investigate these complaints. And there are other concerned authorities. These concerned authorities are in Article 4.22 of the GDPR. This shows us which other supervisory authority is concerned. That means the lead supervisory authority is making a draft regarding this complaint. And if you, as concerned authority, have objections, you can tell these objections to the lead supervisory authority, and they have the opportunity to take these objections into account into their draft. And if they don't want to take it into their draft, then the European Data Protection Board is triggered and comes into the game, and then the board has to decide which decision has to be made. And this decision has to be translated into the national law of the lead supervisory authority. This was just a quick wrap-up of the one-stop shop mechanism of the GDPR, which shows you that the supervisory authorities are dealing with the case, and the unique selling proposition for companies is they just have one interlocutor they have to deal with. So they don't have to deal with 28 supervisory authorities, they just have to deal with the supervisory authority where the main establishment is.
But to Cindy's point about entrance barriers through regulations for smaller companies, do you think that there is a danger in that?
I think if you just open a startup now, you know the rules which you have to be compliant for Europe. In all the 28 countries of Europe, you can work already regarding privacy by design, privacy by default, and this will be a unique selling proposition for your company if you just start it. Because if you start from the beginning on in the right way, you can't fail anymore. And so I think it's really a selling proposition and marketing advantage if you're following the rules, if you want to make business in Europe, for sure.
I'd love to add a little bit to this point if I could. For those not familiar, I wanted to explain at least my understanding of the dynamic that Cindy is referring to. And there are a number of areas of American law in particular, patent law is very notorious for this, where the scope and the breadth of the private right of action in American law and the role that the court system plays, the costs that processing these kinds of complaints imposes on the defendants tend to be so significant that even if the complaints and the actions themselves are completely unfounded in the law, it can put such an incredible burden and risk on companies that it has a severe practical depressive effect on your ability as a business to get venture capital, to get off the ground. It is a legal system here in the United States that is capable of being exploited in ways that have nothing to do with justice. And I think that that's at least part of the dynamic that we worry about when we conceive of a direct translation of the structure and the concepts of the GDPR into the United States. That shouldn't stop us and must not stop us from understanding the principles. I think Mason did a very good job of referring to that, which fits into the cultural context that I was getting at as well, where we need to be more responsible about how we use data, how we collect it. We need to be responsible about limiting the purposes to which it is put after it is collected. I think that there is a legitimate risk, depending on how these laws get written in the United States, that if they are too prescriptive and too specific, it's impossible for a new company to be certain that they are being good enough to avoid risk and liability. And that's the safeguard that we need to protect here. It's one that is different in the American context than it is in other legal contexts around the world. And so I think that point of comparison is really interesting. And to the Max Schrems case, I don't feel qualified to comment on the merits of those specific incidents, but I will say, I believe that we will learn a lot over the years to come over how the text of the GDPR is to be interpreted in practice. I think there are technical questions and legal questions of interpretation that have not yet been resolved. I think we will learn by iterating and by watching the actions of the DPAs and the EDPB over time. And I think that will cut in both directions in the sense of we will learn that certain practices that companies have adopted are not actually sufficient. I think we will learn a lot of practices that have been adopted in Silicon Valley that purport to be compliant with the GDPR are not in fact good enough. I also think we will learn that some are covered by the legitimate interest exception and some of the other relatively generous exceptions within the GDPR. So I think that there is still more to be learned through iteration over time.
So I think I want to move on to the situation here in the United States, but stay with one final point on GDPR. And we kind of felt guilty that we don't have a small company on the panel. So we asked one to give us a short statement on this debate of whether GDPR kills innovation. And we asked Michael Platzer, he's the founder and CEO of Mostly AI, a Vienna-based tech startup that develops solutions to generate synthetic customer data, on whether he thinks that privacy kills innovation. And this is what he says.
No, I would actually claim the opposite is the case, because organizations are forced to, for the first time, really thoroughly look at their customer data assets, and now they need to look for fundamentally new solutions, how they can take advantage of all the information that is available without infringing their customers' privacy. And synthetic data is just being one of those solutions.
So he's basically saying, no, it creates new opportunities for new business models, and they have created one of them. And I want to ask this question maybe to the general, to all of you. So is there, when we think of technologies like artificial intelligence, which is obviously based on big data. Are there, can you reach through regulations, but simply defining the standards, the rules of the game, can you actually create new business opportunities?
Yes. Yes, you definitely can, and I think something like artificial intelligence is it's a neutral technology. It can be used for good, it can be used for evil, it could be used for boring, it could be used for interesting. You can deeply violate the GDPR with it, or not. Something like the GDPR might impact the types of effects that your product can cause on people. Based on the data, or it might affect the kind of data or the availability of training sets for AI. But there's nothing in that law, generally speaking, that should slow the growth of AI. The GDPR is a technology neutral law for the most part. It's not without challenges, but certainly it's something that can be innovated around.
So let's talk about the legislative approaches here in the United States. We already mentioned the California Consumer Privacy Act that is going to be enforced as it stands now in 2020. And it was enacted in the summer by the California legislature and has already been amended immediately after. So the question, what we often hear is that the tech industry isn't really happy with this California legislation, and that it is actually pressuring Californian lawmakers to change it on the one hand, and then that it is also pressuring lawmakers in Washington DC to come up with federal legislation that has weaker standards than the California Consumer Privacy Act. Is that true? Do you feel that is the case? And maybe we can have a different case. But I'd like to start here, and then we ask everybody on the panel.
So that law has big problems. The issues that it's trying to address around harmful or unjust or excessive sale of personal data are valid issues. They're valid concerns, and I think it's appropriate that be subject to legislation. That particular legislation, I think, does not do a good job. It's not a mini GDPR. It only addresses a few topics, like sale of data, access to data. It allows people to sue for security violations, but it is more strict than the GDPR, unforgivingly so, in some areas, and has a lot of impractical things. For example, if somebody opts out of the sale of data, you're not allowed to ask them again for 12 months if they'd like to change their mind, even if the value proposition changes. They're out of the picture. The amount of record keeping that could be required for some companies to be able to meet the information requirements of this law, to be able to tell somebody what types of data you've sold about them, to which particular categories of companies of the last 12 months, is for some kinds of companies very, very difficult to construct, and that's not something that the GDPR requires. And it, for me, there's one part of that law that allows people to sue. There's a private right of action for one part of this law, which is you can sue a company if they experience a data breach as a result of not implementing reasonable security measures for certain limited kinds of data, like driver's license or social security number. The California Attorney General has taken the position that reasonable security measures means compliance with the SANS Top 20, which is a very difficult standard to meet, and there are statutory damages for this violation, meaning even if nobody is hurt, there's a certain amount of hundreds of dollars that you may have to pay per person in a data breach. So I think that's not tethered to actual harm. So I think they went way overboard in pursuit of noble goals that are worthy of regulation, but I think they've missed the mark.
Way overboard, is that how you see it?
So I would say they are underboard. The proposals that were floating through the California legislature before this one was rushed through were significantly stronger. I do think that the bill needs help. The law needs help. I think everybody, you know, what happened here was there was a proposition that was had qualified for the ballot. California propositions are actually very difficult to change. You can't change it with subsequent legislation. You have to pass another proposition. So I think a lot of people were concerned that we had a poorly drafted, in ways that I suspect my colleague over there and I would both agree, poorly drafted proposition that was going to create a lot of trouble. And so what happened was there was a rush to pass a law because a law could be amended. And in that rush, some things were left on the table. Some things were not very well thought out. But I think everybody involved in the kind of last making of the sausage of that knew that we were going to have to come back and finish that law. I think the place where my friend and I disagree is that I think a private right of action is the only way to make something have teeth in American law. And that unless we have that, unless you and I are empowered to say, look, you didn't take good care of my data, you know, you have to have that pressure, or else the companies are just going to nod and wink about it. And I think that there's a lot of work to be done. And so the companies have both worked to try to get rid of that here, but then I think recognizing that they're unlikely to get the California legislature to take out the private right of action that they put in, they are rushing to Congress to try to write a weaker privacy law and preempt the California law. Now, I recognize, and EFF has argued in a lot of other contexts, that having, you know, 200 different laws that you have to comply with different standards is difficult for anybody, whether you're a big or a small company. And the benefit of the GDPR is that it took 28 different things and is trying to make a somewhat common thing there, although, you know, different states still get to make some decisions about how they implement things. So a strong federal law would probably be better than not. But a weak federal law would be worse for us in California and across the nation than this. California has led in protecting privacy. We had a data breach notification requirement in California law long before there were any in any other states. We were the first in the nation to do that. And because of our law, that's why you get notification when your data leaks out. Your data, there were plenty of leaks before we passed the data breach notification law, but the fact that you know about it is because of the data breach notification law that California led the country in. They've still not been able to pass a federal one yet because the companies want to water it down so much, and we've been holding the line. So there is a place for innovation in the states around privacy right now, and I'm very concerned about the federal effort. And there was a pretty good tell about the nature of the federal effort, because the first hearing that the Commerce Department, I think it was the Commerce part of the, I think the House Commerce Committee held, they invited 6 big tech companies to testify about the need for a federal privacy law, and nobody representing anybody else like us, the people who are, you know, presumably going to do. Now, we shamed them. We were with a lot of groups that shamed them. They quickly cobbled together a second one and put some consumer advocates on there. But I think, you know, if you're watching, like, you want to know who's at the, you know, who's at the table. We've had to fight to be even minimally at the table in those conversations on the federal level. So I'm worried about a federal law, and I'm especially worried about eliminating a private right of action. Now, in terms of the question of statutory damages or regular damages, we have a problem. You know, how many of you have ever had your data leaked under a privacy violation? If you don't raise your hand, you ought to. It's just that you didn't notice that notice that showed up, right? Everybody has had their data leaked. How many of you have ever gotten any compensation whatsoever from your data leaking? Yeah, nobody, right? How well are we doing? All right, how many data breaches do we still hear? I mean, we're losing the battle for data security right now, and part of the reason we're losing the battle, why, you know, we've had government databases breaches, we had Target, we had Equifax, we had everything with no remedy, no serious remedy for any of the rest of us, is because you don't have a say in those things, and we have not figured out a way and convinced the courts or the law to recognize the loss to you of having your data flowing all around all the world. And statutory damages, which is what we do in copyright law, it's what we do in Wiretap Act violations, are a way to recognize that there's a value there even if we can't quantify it. And I think it's tremendously important that we start having a serious conversation about what our privacy is worth and how we're going to make sure that people have a means to protect it. The European Union has, a tradition of data protection authorities and other things to people who step up. In the United States, we really don't have anything similar. What we have is litigation with consequences if you mess around with people's rights. And so we need to bring that lever to bear.
So I want to bring here two voices. I think they were interesting. That Tim Cook, the CEO of Apple, just a few days ago said it is time for the rest of the world, including my home country, and he meant the United States, to follow GDPR's lead. But then also Mark Benioff of Salesforce, he said, we really need in this country a national privacy law. You can see it's going into effect in Europe with GDPR. He said that already back in spring. That's a shift we have to make. So big tech seems to be in favor of a national privacy law. What is the true problem? Why is it not likely, or is it likely, or how likely is it that it's going to get into effect? And maybe start with you.
Well, I'm exactly the right person to comment on the likeliness. From what I understand, it's probably not likely to happen in the next 2 years. But do I think there's a big change between a year ago and now, right? I mean, you can think about what tech is going to do with the federal privacy law and undermining CCPA. On the other hand, there is now this call for a federal privacy law, and I think that's a big change, and it's great. It's also great for international transfer, right? We have all these discussions about the US not being an adequate country. I think we're probably not quite there yet either, but there are obviously very good reasons as to why a federal privacy law would be the right thing to do. And again, I think industry understood that. Do I think it needs to look like GDPR? Probably not, right? It's a different culture. Privacy has some sort of a cultural notion, and how Europeans think about that is different. I think it's fascinating to hear like this comment on the First Amendment, for example, because I think Europeans also care about freedom of speech. And we just think about it maybe differently, or maybe the protections around it are different. So yes, I think these cultural notions need to be taken into account, the same for class actions and whatsoever. But is there something to say about that the time is right? Will it happen anytime soon? Probably not in the next 2 years. But at least let's get started and let's have these conversations. And then hopefully under the next president, whoever that might be, something will happen.
I do think there's a chance in the next 2 years of something. I don't think it's a great chance, but I certainly wouldn't rule out the possibility, because the California law comes into effect in January 2020, because everyone agrees that it needs some revisions to be workable, and because we'll continue to see enforcement actions in Europe of the GDPR over that time period. I think the US and US policymakers recognize that they have lost a lot of their mantle of leadership on setting norms in this space, and would like to try to take that back, and would like to try to set some examples about how you can recognize the common shared principles that we can pull out of the GDPR and figure out how to translate into the American legal and political context. I think there is a lot of interest in that.
I would just say that I think that the question to me isn't whether we'll pass something federally. I think that's an interesting question. To me, the question is, will we pass something good? And where will we pass something good? We can pass something horrible federally. We can make it worse. And I think that the question, I don't think that's what Mr. Cook wants. I don't think that that's what Mr. Benioff has. They both have business interests that aren't about making their fundamental money off of tracking your every move. But while Mr. Zuckerberg was in front of the U.S. Congress talking about how he could support better privacy laws, Facebook itself was in Illinois trying to kill a facial recognition law that would have protected your privacy against and given you a voice in how Facebook does facial recognition. So the fact that there are leaders in the tech community who are saying we need a federal privacy law should not necessarily be welcomed as good news. It may actually be bad.
One thing I forgot to say, and I wanted to reiterate Lynn's point about adequacy here, right? And that goes to Cindy's point as well. It's not just a question of whether we have a federal privacy law in the U.S., but whether it is a good enough one to meet the standard of adequacy, which I think is incredibly important. We don't want to have to go through another Privacy Shield negotiations process here. For those who weren't tracking that, it was messy, it was complicated, and if we can avoid that, I think the world as a whole, the US and the internet are all better off. I want people to look to India right now, which is much closer than the US is to passing a data protection law, and it will be fascinating to see if and when India passes that law, whether it will meet the adequacy standard for the European Union, because I think that that will set a really interesting and a powerful example and barometer.
I have a question for Dr. Jelinek. And I know that you don't like to give advice to U.S. policymakers or legislators, so I'm not asking it in that sense. But a French company that is processing the data about French individuals in France is subject to the GDPR, and that's a tough standard. Many U.S. companies that are processing the data of French individuals here in the US, many of them will be subject to the GDPR and will be subject to a very complex array of US laws, some of which in some areas are more strict than the GDPR, some of which are not. So the US company has two sets of laws to follow. So one might argue that already, before a federal privacy law has passed, already the US company, you could think of it as a safer place to process data because it's more regulated. Because the GDPR now applies to many US companies, not all of them, but because of that, how important is a federal privacy law, yet one more US law, do you think, to the decision of the European Commission as to whether to recognize United States law as adequate? Has it become less important?
First of all, I never comment the legislation of a foreign country because it's no use of that. That's the first. The second is we are always ready to share our experience regarding the GDPR and the application of the GDPR. Now it's up to 5 months, but in just a few months it will be up to a year. Maybe the first investigations will already be closed. We will see. And we are always ready to come and share our experiences. Not to give advice, but to share and to have an open dialogue with our partners, also with the legislators. But we are just the regulators and not the European legislators. And that follows your question regarding adequacy. The adequacy decisions and the negotiations regarding adequacy is made by the European Commission. The European Data Protection Board just can be asked by the Commission to give the opinion after their negotiations. So just to make this clear, I think it's fair enough to say that I'm really proud that I'm able to be part of a panel in the United States, in California, discussing GDPR and hearing your commitment to data protection and hearing your commitment to privacy as a fundamental right. And I already quoted you at the US Senate regarding data protection law. And if you had asked me 2 years ago if this could be happen, me sitting here discussing with you in the United States with an audience about, I think, more than 150 people, and also already standing around, I wouldn't have dared to say it will happen. but I think this shows the development of data protection and privacy and the importance of this development in the United States. Because I'm very, very convinced that the US citizens don't deserve less protection of their personal data than the Europeans have. And so I think the same level of protection would be very good.
So I'm going to open up the questions to you. So, and while you think of your questions, I want to ask one last question to whoever wants to answer this regarding the future, the next 5 to 10 years. If you think of if we think of California, if we think of Washington D.C., we're also a bit forgetting the rest of the world. You mentioned India, that is in the process of enacting a data privacy law. There are other countries that have already have or are in the process as well, Japan, Brazil, and all these countries in Latin America, in Africa, in Asia, they matter because the tech industry and the technology is global. So if we look at the next 5 to 10 years, what kind of scenario would you wish for, and what do you think are the challenges? Also, maybe starting with, or also including the situation in the European Union, where there's also discussions of the e-privacy regulation that also concerns data privacy. So where are we, in your opinion, going to head to, and where should we head to in the next 5 to 10 years on a global scale? Maybe starting with you.
Oh, wow. I'm not very good at this. I thought Wired magazine was a really bad idea in the 90s. I think that, you know, what I would like to see, and this is maybe a slight shift a little bit, is I would like to see us build a secure internet. I would like to see us build security and privacy into the tools from the very beginning rather than to bolt them on. And your point about if you're going to launch a new venture right now, maybe privacy by design and differential privacy can be built in from the beginning is, I think, wise and good. And to the extent that the GDPR is spurring people to have to think about that at the beginning as opposed to bolting it on later, it will do a great service to the world. There is much work to be done. We haven't yet talked about law enforcement and governmental access to people's information, and I think that is the great next step. If we really believe that privacy is a fundamental right, it's not just a fundamental right against Facebook, it ought to be a fundamental right against the world's governments. And that work remains to be done. Building in the kind of security so that our tools really do just respond to us and don't have secondary uses and secondary tools that get in their way of serving us. That's our great work for the next 5 to 10 years.
I think I would like to see a universal acceptance of the norms and principles reflected in the GDPR, including in particular the concept of purpose limitation, the idea that you collect data for a specific purpose and you don't use it for purposes beyond that with which you collected it, and so that there's a better, more trusted and transparent relationship that puts users at the center of their internet experience. And I'd like to see that implemented in more and more countries through legal frameworks that also have innovation and entrepreneurship built into the mix. That means not just having the law written in a way that isn't unnecessarily or unduly burdensome, but also having an effective working relationship between industry and governments so that the industry doesn't need to feel afraid and can come to and work with governments to gain better guidance as they need to, so that they feel like they can innovate with data and with users, but do so responsibly and in ways that respect the principles and will end up being blessed and not chastised by the government regulators.
Something that is technology neutral, obviously, like anything that is not, does not make a lot of sense. Something that is based on the principles around transparency, accountability, and really taking the rights of the individual seriously. Anything that requires data localization, because we talk a lot about the good things that we're seeing in the US or Brazil maybe, but India is like doing some data localization requirements, Turkey is doing the same, Russia is doing the same, China is also kind of doing pretty creative stuff over there. Anyway, so these things don't necessarily, You can't tweet me on that one, though. So these things obviously don't necessarily help because international transfer of data is happening, right? It's like most of the companies are multinational companies, and if you have a website, you can't really obviously limit it to just the city of, I don't know, San Francisco. So all of these things, I think, would be the right thing to do.
I look forward to more development of inter-industry cooperation to create standards for communicating privacy information, like the IAB consent spec for dealing with consent and the advertising technology ecosystem that allows companies to communicate with each other in a standardized way about whether consent was given. I think that kind of technology has real value and can solve a lot of challenges, and I look forward to seeing that develop more.
Thanks. I would nearly dare to say nothing to add because you're quoting the GDPR, the sense of the GDPR, the sense of the fundamental right of data protection. But I just want to add something regarding ethical principles within the next 5 to 10 years. Based on a common approach, I would love to see these ethical principles that not everything what is possible technologically is really going to be used. This would be really helpful for all of us, for us and our children and grandchildren, that we come to a common ethical standard from all over the world, because we have different concepts of legislation, we have different cultural backgrounds, but we all want to have a secure future for us and our children. And I think ethical principles would be very helpful for that.
Please. Thank you.
And maybe you can start with introducing yourself.
Burton Lee, Stanford University. Following on this question and specifically Cindy's response, it seems to me that looking 10 years down the road, we're going to see the rest of basically the world lined up against China, and specifically the Chinese Communist Party, because Alibaba, Tencent, Baidu, all the consumer companies who are operating in Europe or around the world are going to have to comply with this. Huawei, but also state-owned enterprises in China. And so it seems to me that this is a massive, perhaps the biggest challenge the Chinese Communist Party will have ever faced politically, because this is going to permeate throughout Chinese consumer culture and many parts of industry culture. So my question to you is, I don't know if any of you can answer this, what are Chinese legal scholars saying on this? What are the discussions happening in China today around this issue, or in European, US think tanks who look at China and work with China? Because this is a very fundamental challenge to the current surveillance system that China is putting in place. And so moving on to, building on your comment about moving this into government, this is a fundamental challenge to control of the Chinese Communist Party of the Chinese population.
The winner takes it all. No. Nobody wants to take the mic. Okay, I take. I think nobody in here knows, but because I don't think I don't see any hand raised who knows the answer, and nobody wanted to take the mic. But as far as I know, there are discussions in China. And there are discussions in the scientific and university world, but maybe they have a different approach. And I'm sure we are going to talk about this with our Chinese colleagues, and you are going to talk with them. But we will see what the future is going to bring. No crystal ball in the room. But we are all, it's the duty of all of us, I think, not to lose the contact. I think dialogue is really important. And who wants to take the mic now?
Well, I mean, I'm happy to comment on the law itself that they passed. So it's going to be specific, I mean, certain things enter into force January, whereby data needs to stay in China. So there are specific data localization requirements. Why the Chinese feel that they need to do that, I don't think that's for me to comment. But I think we have a lot of smart people in the audience that might understand why that's the case. Do we think as a company that that's helpful? Not really, because if everybody is gonna start doing that, data localization does not increase privacy. It doesn't increase security. I don't believe in that. So I don't think that's the right path to go. And hopefully a dialogue from, well, maybe the US government with China could help there. I don't know.
So you challenged the audience, anybody in the audience on China or on, and yes.
Hi, I'm Danny O'Brien. I'm the International Director at EFF, so I think my job depends on having answers to things like this. I think one of the things that's going to be very interesting in China, and we're just beginning to see, is the same sort of grassroots pressures that led to the strengthening of data protection law in Europe, and exactly these sort of calls going on in the United States from consumers who are concerned about the loss of their data, is something that we're also seeing in China. Now, that doesn't affect law enforcement and government access, but I think it brings privacy into focus. There are data breaches, there's commercial misuse of data in China, and I think that's going to lead that conversation. I think it's very different to talk about the Chinese Communist Party's access to that data. But as Cindy said, if you minimize the data that companies are keeping, that at least prevents them being a honeypot for other interests. Thank you.
Any other questions in the audience? In the back, yeah? Oh, there.
My name's Mark Cohn. I'm the head of legal for a B2B company located in San Francisco called Segment. We're about 300 people. I have a comment and a question. First comment, certainly Mark Benioff and Tim Cook are definitely big tech. I would not extrapolate from that big tech supports federal privacy legislation or anything GDPR-like. My question is actually about data breaches, though. I think both the ICO in the UK and the IDPC in Ireland recently have made public comments about they're getting overwhelmed by breach notifications. And as heading up a legal department for a tech company, that kind of cuts both ways. It makes me think, one, yeah, maybe we shouldn't send a breach notification if we had a security incident because they don't want us to. But on the other hand, I don't want to be an outlier, and it makes me more likely to err on the side of notification even when it may not be strictly required. So I'd like to hear the thoughts of the panel on that.
I think the law is pretty clear actually there. Like, you don't need to notify any security breach. You need to consider the harm and the impact on the individual. And if that's there, then you need to notify. So, and I think a lot of companies obviously panicked and might have maybe filed whatever just to be on the safe side. But maybe that's why you then have a good legal team that makes the assessment on a case-by-case basis, obviously, as to what you need to do. But I think there actually GDPR is pretty clear on when you should notify and what to do.
I agree regarding the data breach notifications, but I also have to tell you that many companies are notifying because they are not sure, because they didn't look into the GDPR. That can happen. And the second thing is, it's better to notify and to tell the affected individuals, because if you try to hide from the individuals, you lose the trust, and the trust of your customers, the trust of your consumers are the future of your company, not the data of your consumers or your customers. Because I think, and I'm convinced, that the trust is the gold of the 21st century and not the data. because you can lose the trust of your customers within hours, and you had to work for 1 or 2 generations to build up your company. So I think it's really important to keep the data of your customers secure and sure, and to follow the rules.
Hi, my name is Calvin Liu. I co-founded a cybersecurity services company called Ventura about 3 years ago. My question is primarily for Dr. Jelinek. I'm curious what the early feedback is on the Article 33 72-hour rule, because as a professional in this field, it is extremely challenging to be able to conduct investigations and understand really what happened in a breach situation, much less be able to encapsulate and notify a governmental authority in a 3-day period.
Just a short answer. The first notification has to be within the first 72 hours. We already had 18,000 notifications all over Europe since the 25th of May. There was no problem to make it within the first 72 hours, and afterwards you have time to investigate it, to investigate the breach. You just have to explain what you are doing, and also notifying the breach to your consumers, to the affected people, is really important, not only for them, but also for you.
So also actually, it's not 72 hours and that's it, right? The law actually, the law actually gives you, if you don't yet know what happened, then maybe you shouldn't notify because you might not meet the criteria. But it doesn't say it's 72 hard stop. It actually says that you can have more time if you have good arguments to do so. And I understand, obviously, that it's sometimes complicated, but for me, this is one of the many misconceptions under GDPR. It's not 72 hours as such. It's not all based on consent. There are other good legal bases, etc. And this is where I think there is a little bit of education to be done, and where sometimes we really focus on these individual issues while not seeing necessarily the bigger picture.
You have the time to investigate the breach. That's the point. You just have to notify that there is a breach, and afterwards you have the time to investigate by your own too.
I want to end this conversation by re-quoting what you just said, because I thought it was so beautiful. Trust, not data, is the new gold of the 21st century. We at Open Austria, together with our partners and friends from Europe and from Silicon Valley, we would like to continue these conversations about societal policy responses to technological changes and do this with you. So we are really, really grateful that you came tonight. I want to thank the EU delegation for sponsoring this event and our colleagues from the EU Consul Generals. And I would like to, last but not least, thank the Open Austria team for putting so much work into tonight. Please, if you can, sign up to our newsletter. Yeah, I think it is GDPR compliant. We hope that. And it's opt-in, and not opt-out. And opt-out is included in the package. So hope to see you soon at our next events, and thank you for coming.